Hello everybody, welcome back to my YouTube channel. My name is Rishabh and this is our revision lecture number 11 of entire MCQ oriented fast track batch of CA Final SPOM, that is Corporate and Economic Laws. And in this video we are going to cover your chapter number 9 of your SPOM set A, which is basically adjudication, special courts NCLT and NCLAT wala chapters. We will be covering the entire all the relevant and important provisions which can come in your examination. Now, without wasting much of time, let us begin. Before moving forward, let me tell you, this entire PDF you can get in the Telegram channel, the link of which is given into the description. Please do join that channel so that you will not be able to miss out any update, any kind of further videos, any kind of further notes that I will be uploading onto that channel. So please do join that channel and you will be able to access all these documents over there. Now let us start with chapter number 9, which is adjudication, special courts, NCLT and NCLAT. Now under Companies Act 2013, there are following a dispute resolution forum. Matlab, if an order has been passed by the ROC, so against that order, either you can make an appeal, either you can go with compounding of that offense, or there may be special courts, or maybe compounding of offenses, or there is SFIO. So we are going to understand each and every point in the detail. So under Companies Act 2013, there are totally 5 types of dispute resolution forum. Number 1 being NCLT and NCLAT, which is basically stand for National Companies Law Tribunal, and NCLAT stands for National Companies Law Appellate Tribunal. Point number 2 talks about special courts. All these 5 points we are going to study detail in this particular chapter, except this SFIO point, because this has been already covered in the chapter number 4, that is inquiry, investigation and inspection chapter. So special courts we are going to study in detail in the subsequent part of this chapter. Compounding of offenses, again, apart from going for an appeal or going with the special court, you can directly compound such an offenses by paying of certain amount of fee or certain amount of fine, and your offense will be will be maaf, for some reason it will be maaf. Now mediation and the conciliation panel. So this is also we are going to study in detail in the subsequent part of this chapter. Now firstly let us start with NCLT and NCLAT. If you see in your module, there are section number 420 to 424 of Companies Act, which talks about NCLT and NCLAT provisions. Totally 5-6 pages are there. What I have done is I have made a very small summary of these. This much is the entire summary which will cover your entire chapter, entire special courts, entire NCLT and NCLAT provisions. So if you even go through this particular chart, you will be easily able to remember all the provisions, and this has the ability to come into your examination, and this is very important from your exam perspective as well. Now, before understanding this, let me tell you, you have to go in the downwards to upward direction in order to understand this chart. Now let us start with the point number 1, NCLT. An appeal against the order of ROC or maybe any other person can be made to NCLT. It can be made to NCLT, but what is the time period up to which it can be made? So under different provisions, different timelines are being prescribed, by which you have to make an appeal to the NCLT. So appeal to NCLT is to be made, can be made by the aggrieved person if he is not satisfied with the order of the ROC. Once you make an appeal to the ROC will pass an order within how much time limit? ROC will pass an order within 3 months plus 90 days of extension can be granted. Condonation of delay is allowed for passing an order by the NCLT. So NCLT has to pass the order within 3 months plus 90 days of extension is also allowed. Now before passing an order, reasonable opportunity of being heard is to be given by the NCLT to the concerned person, and order can be amended up to 2 years except where appeal is made. Matlab, if NCLT has passed an order, then NCLT can itself suo motu can amend the order, provided that no appeal has been made in respect of that order. If no appeal has been made, only in such a case NCLT can amend that order. Now if NCLT passed order with the consent of both the parties, then appeal to NCLT is not allowed. There is one level of NCLT. Let me first give you a brief of this chart. So there is one level of NCLT, there is one next level of NCLAT, and there is a third level of Supreme Court. Okay, so this is basically the hierarchy of the levels. So firstly we will go with an appeal with NCLT, after that NCLAT, and after that Supreme Court will come into existence. So now let us move forward. NCLT you made an appeal, NCLT passed the order within 3 months plus 90 days of extension is also allowed, and these are the 3 points which has been highlighted on both the sides of this chart, which are very important. Now you made order is made by the NCLT and you are not satisfied with the order of the NCLT. Now what you can do, you can make further appeal to NCLAT, that is your National Companies Appellate National Companies Law Appellate Tribunal, and appeal can be made within 45 days plus 45 days of extension is also allowed. That means 45 days of condonation of delay is also allowed if there is a reasonable cause. Once you have made an appeal to NCLAT, NCLAT will pass order within 3 months plus 90 days of extension can also be allowed to the NCLT. This is basically the speedy disposal scheme of the Companies Act, and under that scheme, orders to be passed within 3 months plus 90 days of extension can be granted maximum. NCLT passed the order. Against that order, can you make a further appeal? So the answer to the question is, if you are not satisfied with the order of the NCLT, then you can make the further appeal to whom? To Supreme Court, and appeal is to Supreme Court within 60 days plus additional 60 days can be granted against the order of NCLT. Additional 60 days ka extension, that is condonation of delay, is allowed against the order of the NCLT. You can make appeal to the Supreme Court under these provisions. So these are basically the main provisions of your NCLT and NCLAT. If you remember this, I am damn sure you will be able to easily crack any kind of MCQ in the examination. Now point number 3 talks about tribunal may, under any proceedings for winding up or under IBC code, to take custody of any property, books of accounts or other documents, obtain assistance of Chief Metropolitan Magistrate, Chief Judicial Magistrate of District Collector. Tribunal, if it deems necessary under IBC Act or under winding up, under these two circumstances, in order to take the custody of books of accounts, immovable property or any other asset, then it may take assistance of Chief Metropolitan Magistrate, Chief Judicial Magistrate, and third one is District Collector. Point number 4 talks about no suit or legal prosecution against any person who has acted in the good faith. So this line we have learned almost in all the provisions. If somebody has done any act in the good faith, then in a good faith, then in such a person cannot be liable for any kind of suit or legal prosecution. No civil court shall have jurisdiction to entertain any suit or proceedings which is pending before NCLT or NCLAT. That means any kind of prosecution or suit which is pending against NCLT or NCLAT, then no civil court shall have a right to interfere in those kind of prosecution or appeals, prosecutions or proceedings. Any party to the proceedings may either appear in person or may authorize one or more chartered accountant, company secretary, cost and management accountant, and a legal practitioner in order to represent themselves into the tribunal. Now point number 7 talks about tribunal. So all these provisions, point number 2 to point number 6 was with respect to NCLT and NCLAT provisions. Now let us move forward with special court provisions. Now special court section number 435 talks about special courts. Central government may by notification establish or delegate as many special courts for the speedy trial of the offences. That means if there are more number of offences are being committed, then central government may by way of notification establish or designate as many, how much ever of number of special courts as it may deem fit, it can notify them for the purpose of speedy trial of the offences. Now what would be the composition of the special court? So if case offense punishable for imprisonment of 2 years or more, if there is a case under which offense is committed and that offense is punishable for an imprisonment of 2 years or more, in such a case the composition of special court would be as follows. It would be a single judge holding office as senior session judge or additional session judge. An MCQ can be framed in the examination. There is an offense that has been committed and the punishable imprisonment period is of minimum 2 years. Then in such a case, what would be the composition of special court? So the composition would be a single judge who would be holding office as a session judge or as an additional session judge. So this is with respect to imprisonment case, and in any other offense which is not punishable with offense or which is not punishable with imprisonment or punishable with imprisonment which is less than 2 years, then in such a case a metropolitan magistrate or judicial magistrate of first class are being the composition of the special courts. Point number 8 talks about offense which is triable by the special court. So I would recommend these 8 number and 9 number point to refer to the last of the module, last of this PDF. We will be also discussing that in the subsequent parts. Now point number 3 with respect to compounding of certain offenses. We learned special courts. We have completed this point. We have completed special courts. Now let us move forward with compounding of offenses. Now compounding of offenses, you will pay certain amount of fine or certain amount of fee, and you will be discharged from that offense. Now, okay, compounding of offenses. So offenses are 2 types of offenses which are compoundable and non-compoundable. These offenses, where is imprisonment is mandatory. In such a case, those offenses cannot be compounded. If you read this, if there is a compulsory imprisonment or there is a fine, along with that a compulsory imprisonment period is also prescribed, then in such a case those offences are non-compoundable and you cannot compound those offences. Compoundable offences maximum fine 25 lakh तक का होगा if regional director allows, and in other cases NCLT may direct may go with may compound such offences as the amount of fine as it may prescribe. Now, if similar offence is committed within 3 years, then such offence would not be compoundable. Matlab, once an offence was committed, then that offence was compoundable offence. Now, similar offence, similar kind of offences you have committed in the subsequent 3 years, in the next 3 years, similar kind of offence is being committed, then in such a case, such an offence will not be compoundable even if it was compoundable last time. If an investigation is going on, then such a case also no offence would be compoundable under your Companies Act 2013. In non-compoundable imprisonment of 2 years or more, then special court session judge or additional session judge would be there to settle down that, and other cases special court would be there. Now, let us understand this small chart. Offences, there are two types of offences. First one is compoundable and type 1 and type 2 offences. Type 1 would be covered compoundable, non-compoundable, which we learned over here. This one we have learned compoundable and non-compoundable offences we have learned over here. Now, the second type of offences are cognizable and non-cognizable offences. Now, what are cognizable and non-cognizable offences? Let me tell you. Cognizable offence is an offence under which police can arrest without having an arrest warrant with them, and it is a known bailable offence. That means if a serious crime is committed, in such a case an offence would be considered as a cognizable offence and police can arrest any person without having a arrest warrant. In case of non-cognizable offences, police can arrest only with the arrest warrant and it is a bailable offence. Now, point number 4 talks about point number 11, which is basically point number 4 of this chart, which is mediation and conciliation panel. So this one we are going to understand here. So mediation and conciliation panel, you can say out of court settlement. That means instead of going with the court, you can just settle down any kind of dispute out of the court. So resolution between the two parties with the help of third party. That means a third party would be established, which would be responsible for the settle down of the dispute between the two parties. Now, who can recommend matter to the panel? That means a matter can be recommended to the panel by any party to the proceedings can apply to the central government, NCLT or NCLAT for the purpose of referring the matter to the panel. That panel means mediation and conciliation panel, and NCLT or NCLAT central government can also suo motu do so. Sorry, matlab either any party to the proceedings can apply to the central government, NCLT or NCLAT for the purpose of referring the dispute matter, the matter to the panel, that is mediation and conciliation panel, or the central government, NCLT or NCLAT may suo motu refer any matter to the panel. Now, panel shall follow the process and dispose matter within 3 months and forward the recommendation to the central government, tribunal and appeal tribunal. Matlab, panel shall follow the process, whatever process is described under those sections, under the provisions, and shall dispose of the matter, and within 3 months shall forward the recommendation to the central government, tribunal and the appellate tribunal. Any party who is agreed by the order of panel can file objection with the NCLT, NCLAT and the central government. So this was with respect to your mediation and conciliation panel. Now section number 446. So we have learned all these 4 provisions of this particular chapter. Just a second, let me change the color of highlighter. Okay, so let's take this. Okay, so these 4 points we have covered over here, and this 5th point is pending. So this 5th point we have already covered under your chapter number 4, that is inquiry, investigation and inspection wala chapter. So SFIU is covered over there, and these 4 points we have discussed very briefly, and which are very relevant provisions we have only discussed in this particular notes. Now, let me change the highlighter color, just a second. Yeah. So, okay. Section 446B. If one-person company, small company, startup company or producer company, or any officer of these 5 companies, that is OPC, small company, startup, producer company, these 4 companies along with the officer of any company fails to comply with the provisions of these acts, then company would be liable for a fine which shall be half the amount of fine that is prescribed in that section, or maximum it would be, how much? Maximum it would be 2 lakh rupees under section 446B, and officer shall be liable for a maximum of rupees 1 lakh whoever is in default. So this is with respect to penalty provisions. Now, adjudication of penalties. Central government may appoint adjudication officer, adjudicating officer for imposing penalties before penalties issue. A central government may appoint any person for the purpose of appoint any person as an adjudicating officer for the purpose of imposing penalties, but Such an adjudicating officer, before imposing penalties, shall issue a notice to whom a notice to be issued to the company or the officer and any other person, or to show cause within period mentioned in the notice, which shall not less than 15 days and not more than 15 days, 30 days. That means a notice would be issued by the adjudicating officer to the company or the relevant officer, and such an officer or the company shall respond to such a show cause notice within 15 days and maximum of 30 days as the time period which is allowed in the notice. So the maximum time period that can be allowed is 30 days and the minimum period should be of 15 days. Please ensure that this NLT stands for not less than and NMT stands for not more than. So please be very careful with these short names. Now, order of penalty. If there is a physical presence, then within 30 days of reply, order of penalty is to be passed. If there is a physical presence, if there is no physical presence, so please mark it as no physical presence. The word over here missing is no physical presence, and here it is physical presence, then order is to be passed within 90 days. Section 454A. If company officer any person commits same default second time within 3 years from the date of penalty order, then penalty would be for the second and subsequent default would be twice the amount of penalty. Matlab, same offense is committed in the next subsequent 3 years. Matlab, the same offense is repeated in the next 3 years. Then, in such a case, the second offense on the subsequent offenses, the penalty amount would be twice the amount of penalty that was charged in the previous order. So, this is basically the provision with respect to NCLT and NCLAT. Okay, I think hope you are clear. If you have any other concerns, please do let me know in the comment section. I will try to respond to you as soon as possible. Now, offences which are triable by the special courts. Now, as you remember, we have marked certain points over here. Point number 8 and point number 9 we had to discuss. I told that we will be discussing at the end of the chapter. Now, let us go with those points. Now, in case of special courts, what are the offences which are triable by the special courts? Now, offences which are triable by the special courts. Now, powers of the special court. Offences that are triable by the special court. All offences under section 435(1) shall be triable only by the special courts, which is established for the area in which the registered office of the company in relation to which the offence is committed. Matlab, where the ROC of the company is situated, registrar of office of company is situated in such there, all the offences are triable under the special courts. If more than one special court is there, then any one of them as may be specified by the High Court in such behalf. Where a person accused of or suspected of the commission of an offence under this act, and such person is forwarded to the magistrate. By what is the time limit? If he is forwarded to the magistrate, then such magistrate may authorize the detention of such person in such custody as he thinks fit for a period not exceeding 15 days. So here the time period is 15 days in the whole, where such magistrate is a judicial magistrate. Matlab, if such person is forwarded to the magistrate, so the magistrate can be of two types. Number one being, it can be a judicial magistrate, and number two, it can be a executive magistrate. If it is a judicial magistrate, then such magistrate may authorize the detention of such a person in such custody as it thinks fit for a period of not exceeding 15 days. Matlab, if he is a judicial magistrate, he can have a custody of such period for a period not exceeding 15 days. But if such a person is an executive magistrate, then in such a case, the maximum detention period would be of 7 days. Please be very careful. These are very, very important from exam perspective. This is not relevant. Cognizance of offence by special court. A special court may, upon perusal of the police reports of the facts constituting an offence under this act, or upon a complaint in that behalf, take cognizance of that offence without the accused being committed to it for the trial. That means it has suo motu, can do so if he thinks fit. If based upon the complaint or based upon a report by the police, it can do so. Offences which are not cognizable. Matlab, these offences to be non-cognizable. Matlab, these offences can only be a person can be arrested only upon having the arrest warrant with the police officer. Now, nature of offence. Every offence under Companies Act 2013 except the offences which are referred in the section 212 subsection 6. This is basically an inquiry investigation wala chapter. Under those offences, all the offences under the Companies Act are basically non-cognizable. Matlab, they shall be person shall be arrested only if the person is having if the police is having a arrest warrant against that person. Court shall take cognizance of any offence under the Companies Act which is alleged to have been committed by any company or any officer thereof only on the written complaint of the registrar or the shareholder or the member of the company or a person authorized by the central government in that behalf. Matlab, Cognizance can be taken if a complaint has been filed in the writing by the ROC, registrar, or the member of the company, or any person who is authorized by the central government. With respect to cognizance of offence relating to issue and transfer of securities and non-payment of dividend, matlab, there is a offence which is basically kind of issue or transfer of securities or non-payment of dividend. Then the court may, on complaint in writing by a person authorized by the SEBI, can take cognizance of such an offence. Non-applicability of this section not apply to prosecution by a company of any of its officer. To a prosecution by a company of any of its officer. Now, this is not relevant. This is also kind of not relevant. If you, even if you leave it, not much of, just give it a read, you will be able to easily understand it. Now, summary trial. That means not anything contained in the Code of Criminal Procedure 1973. Power of special court on summary trial of any offence. The special court may, if it thinks fit, try in a summary way any offence under this act, which is punishable with imprisonment for a term not exceeding 3 years. In case of conviction in summary trial, no sentence of imprisonment for a term exceeding 1 year shall be passed. Matlab, maximum imprisonment can be 1 year under your conviction of summary trials. This one also, if you give it a read, you will be able to understand. That's all. That's all in your entire chapter. Do let me know in the comment section if you like the video. Please share this entire playlist to all your friends. Whoever is having doubts with respect to whoever is having any kind of fear with respect to passing of SPOM examination. That's all about it. Thank you so much. Thanks a lot for watching. Thank you so much.